I understand and realize that some of you are brand new to your roles. So congratulations. And the answer, I have no idea, is perfectly acceptable and will be for a while. So today is your day to use the I have no idea card answer. So that would be great. So let's talk about some of the very basics. And if I'm getting too basic, y'all shoot me a chat or shoot Diane a chat and have Diane let me know. And we will take things up a notch. But schools are so unique in the United States. And I threw in the United States because for those of you who may have worked globally or outside of the United States, employment contracts for every single employee are very common outside of the United States. But here in the US, almost no employees have employment agreements unless we're in the independent school realm, in which case an awful lot of independent school employees have those contracts. Sometimes we see just faculty with a contract. Sometimes we see the addition of admin. Sometimes we see the addition of everyone else, which now means we're at the entire school and everybody who's employed there has a contract. And that's unusual. And so I do encourage schools to ask yourself, why do we have contracts and what do we get out of them as a school? And I have found over the years that many independent schools have very compelling arguments about what they feel like they get out of those contracts. And ultimately, if it makes the school feel good and there's value to you, then the fact that this is sort of unusual as a business practice or an employment law practice really becomes irrelevant, because with a good contract, you're certainly not doing any harm. And so if you like what you're getting, great. But I still remember probably a decade ago having a conversation with an independent school, and the head ultimately got around to a question and said, "You mean I don't have to sign each and every one of these personally?" And I said, "Excuse me?" And so the head was still taking like literally an ink pen and signing every single one personally, because that was just sort of the history, the tradition, the connection between the head and the rest of the school. They were very pleased to get away from that old practice, but they did keep their contracts for much longer after that. But I think they finally moved away. So if you didn't do a contract, what would you have? Without that special piece of paper or that email these days, probably, all of your employees would be employed at will. And that is the general concept that both the employee and the employer can make the choice about continuing the employment relationship for any reason, no reason, good reason, bad reason, as long as the reason is not unlawful. And the unlawful really only comes into play for the employer. So there are always things that the employer can't do. You can't engage in unlawful acts. You can't harass. You can't discriminate against people. You can't retaliate against people. You can't have whistleblower problems. So as the employer, there are always things that you are limited in doing. There are relatively few things that an employee is limited in doing, but that's how the at-will standard works. I do hear the phrase employment at will confused with a different phrase, right to work state. Every state that is reflected on the sign-in sheet is, well, actually, I don't know about the Virgin Islands, so apologies in advance. I wish I did. I think I need to do some on-site research as soon as possible. But every state that's listed here that somebody has registered from is both an employment at will state and a right to work state. The phrase right to work is a union concept, and so I hope for all of you, you never have a reason to use that phrase, but don't mix that phrase up with employment at will. And that is something that I see all the time, especially for individuals who are newer to a human resources responsibility, is that people come to me and say, well, I know Georgia's a right to work state. I know Florida's a right to work state. And that means I can just fire this person. Well, you're correct about the designation right to work, but you're incorrect that that's the reason you can, quote, just fire somebody. So don't confuse employment at will and right to work. So if you do go ahead and issue a contract, and I'm going to assume that most of you do, or historically have done so as a school, what that contract can do, first and foremost, it doesn't have to alter the at-will employment relationship. And I will say the vast majority of independent schools that we work with at Fisher and Phillips have migrated from an employment contract that meets those last two bullets that you're seeing on the slide to an employment contract that just restates the notion of employment at will and then fills in some other terms. So chances are you have an employment at will agreement, still a contract, but it is possible to do away with employment at will. And the main way that a contract does that is to have a defined period of time in which the parties can't separate without some type of penalty. And that penalty is usually ongoing pay for the school. And sometimes there is an attempt to bind the employee. And we'll talk about that a little bit and how it doesn't necessarily work all that well. Or the contract can have other provisions in it that change the basic concept of at will. Again, that concept that we can end this relationship at any time, either the employer's choice or the employee's choice. The contract might have a definition of just cause. That's the only reason you could terminate somebody. In other words, you have a really good reason. If you ever see a document with just cause language, just cause always needs a definition. Just cause as a phrase doesn't have its own definition. I have clients call and say, well, you know, I want to terminate this person for just cause. And I say, well, what is that? And they say, well, you know, just cause. And I'm like, well, how do you define it? How does your industry define it? How does your company define it? And if it's not written down somewhere, we would have to ask a court to help us interpret that phrase. So be very, very careful if you use that phrase or see that phrase in a document anywhere. The other way we could change employment at will is you could create an employment contract that said employees had to be written up possibly for a certain number of times or have to have a written warning on file before they might be terminated. So anything that sort of alters that ability for an employer or an employee to say, I don't want to be in this employment relationship anymore, is taking you away from employment at will status. So just real quick, how do we end up with a contract? It doesn't necessarily have to have the word contract in it. An agreement is a contract. An offer letter can be a contract. Any document that a school issues to employees can be considered a contract, which is why some of you might find that many of your documents have, this is not a contract, written on them somewhere or contained in them somewhere. But it's basically an agreement to employ or to do something else. There's typically a definite duration, even if that duration is an at-will type duration. It's going to contain specific job duties because we need a certain amount of specificity in a contract. It can't just be sort of open-ended. In the employment context, there's going to be a promise to pay, and it needs to be signed by the person who agrees to be bound. So those are some really broad overview concepts for contracts generally. And so now let's take a few minutes, and I would love to hear from some of you. Within your school, do you use contracts? Who gets those contracts? What do you call them? Are they at-will contracts, or do they have a defined term? And if you have something other than at-will, do you know if that contract contains specific reasons for ending? So I'd love to hear from you. Like I said, even if all you say is, you know what, I'm brand new and I haven't paid any attention to these contracts yet. That'll help us with where we go next and what we talk about.
Hey, Jennifer, I can go. I started at Mount Vernon in November of last year, and so this year, and I'm new to independent schools, so this year was my first foray into contracts. And we actually this year stopped doing contracts for anyone other than our teachers because it didn't make sense for us, but we still keep a defined term for our teachers.
Okay, and what led you to say we see a reason to get rid of this for non-teachers, but we like this for teachers?
Yeah, for the teachers, it was really more just industry standard and what they expected. But for everyone else, it was just a lot of work for something that they really didn't see a value in. So that's kind of why we got rid of it.
Makes sense. And for the non-teachers, were those really at-will agreements, just
Yeah.
in the framework of some type of contract?
Right. So it was really just busy work to do contracts for, you know, our non-faculty people. So, yeah.
Absolutely. Congratulations, Courtney.
Yeah, it was great.
Progress, change. Anybody else?
Well, I'll just say that at our school, we have contracts for everybody. Even the hourly workers, like we have some assistant teachers that that we put in the hourly wage in the contract, and we obviously have used Fisher and Phillips for our contracts because we have all those items that you list there that a contract should have in there. So fortunately, at least legally, our contracts are pretty good.
Awesome. Thanks, Suzette. So I also, about half of you on the call are Fisher Phillips clients or have been in the past. But one of the things that you might notice, and as Suzette pointed out, here I am, you probably are getting a sense that I'm not a huge contract fan, but that doesn't mean that as a law firm, we don't support a school that comes to us and says, we get something out of this process. And so as long as Suzette and her school get something out of their contract process, that's the right answer for them. And so we create the best contract for them. Flip it to Courtney and the example she just gave. Her school was not getting much out of contracts, and just, you know, all the way to the point of calling them busy work. And that is the right answer too. And that's one of the things that I think makes employment law fun. But then my job is being an employment lawyer. For those of you who are now stepping into your role where you have to lead the HR function or have some oversight into the HR function, I can see why you would be thinking about pulling your hair out, because wait a minute, how can both Courtney and Suzette be right? But there's a lot of room for doing things in different ways when it comes to many aspects of employment law, actually. Anybody, do we have a third volunteer who wants to give us a different perspective?
I don't know if my perspective is entirely different. We have contracts for all of our employees, as far as I know. I think contracts serve the purpose. I don't know, I've never really thought about that before this moment, but I think it serves the purpose of defining your salary, defining what raise you got, defining the potential different layers of your salary. You know, if you do an after-school thing or if you coach, those kinds of stipends would be included in there. There's also, in our contracts, we definitely have command performance days where you're expected to attend like an evening function or a Saturday function or that kind of thing, and they define those. And if you're not going to attend them, what process you need to go through. You know, if you need to be excused for this reason or that. Mm-hmm. And also there is, and I don't remember really what many of them are, even though I read my contract every year, but reasons for like just immediate dismissal.
Right.
And our headmaster, I think, always signs them. And it is, you know, it's definitely, it's a paper process. But I think in general, with me coming on, we're moving away from part of my main task has been to electronify us, to try to cut down on the number of file cabinets that we have throughout campus.
Good.
Contracts may be a part of that. I hadn't even thought about it, but.
Right. So William raises a great point, which is, how do you convey certain information if you don't do it via the contract? And clearly, again, outside the realm of independent schools, businesses, lots of different types of businesses, convey the same type of information. They just do it in a different way, possibly via an employee handbook, possibly via an offer letter, possibly through policies and procedures, possibly through formal performance evaluations. The information that gets conveyed is important information, and does have to be conveyed through some type of vehicle. It's just most businesses don't like to send sort of that, this is a contract message, and schools really, for the most part, enjoy it. So again,
if I can just say one thing about the contracts, one of the things that's nice about the contract is that in our school, it's just for the year. So if you have someone that perhaps is not performing all that well, you just simply don't renew their contract. And so it's a nice way to handle that without making it like an ugly thing where you actually have to call someone in and fire them.
Right, right. So I 100% agree with what Suzette just said. Two important things to remember. First, it is a much more pleasant conversation. We've decided not to renew your contract for next year. That sounds so nice. Because your alternatives are, we're not happy with your either performance or the way you follow our rules. So you either have to get into, you're not a very good teacher and this is why. Obviously lots of subjectivity there, and no teacher wants to hear that he or she is not a good teacher. Or you don't come to those command performances like we ask. You always have an excuse. We're tired of those excuses. You're never on time. You don't complete your reports. You're not good with parents. Those are harder conversations to have. However, remember, your legal risk is identical. Saying to someone, I'm not renewing your contract, is just tying a bow on you're fired. It's easier to say, it's easier to hear, but to the extent there is legal risk, nothing has changed about the legal risk. So if you feel like there is protection because you're not renewing a contract, you're wrong. You just have to know how to manage the risk that you would be having if you were saying you're fired. The great point, Suzette, because I do think it makes for a much, much easier conversation.
One of the things our contracts have in them, which I've always kind of been entertained by in my different roles, is either party can terminate this contract at any time for any reason.
Right.
So
which means you have a contract for at-will employment, which is absolutely what we suggest. If you're going to go the contract route, our first choice for you as a school is that you have employment at will agreements. And then our second choice is that you have just cause language that is very, very much in the school's favor. That's a very, very low burden for the school to have to meet in terms of just cause. Our least favorite is you have to do something terrible to meet that cause threshold, because as a school that really ties your hands. Okay, let's take a look at a couple of other points in our last few minutes. You all have hit on some of these pros and cons. Pros, I think there is the feeling of obligation on behalf of the faculty and staff. If I have signed this contract, if I have committed to the school year, I need to stay and finish that out, so you end up with some continuity. We all know that within the education industry, so to speak, most faculty in particular do tend to change jobs all about the same time, and that's a very delicate dance as people decide to leave and take offers other places, and how all that shakes out. But it does tend to happen all at the same time, which I think is one of the reasons we see contracts continue to exist. The other thing that we can see is built-in remedies for early termination. And this is where I said, as the employer, it is very typical that you are going to have to make some type of payment if you have a contract that's anything other than at will. So that's your liquidated damages is, I'll pay you a month's pay even though I'm not going to ask you for any services, even though I'm ending your contract. I have seen some schools that have provisions where if the employee does not live up to their agreement, which is staying throughout the school year, that there is some penalty to the employee. You owe us $1,000. That language is easy to write. It can be hard to enforce. It can be even harder to collect. There's some states where it really wouldn't be allowable. But again, sometimes we do things that are a little bit of a push if you feel like you really need to tie your faculty's hands where they couldn't leave you. So something to think about. What's the flip side? What's the downside potentially on contracts? If you have anything other than at will, it ties your hands as an employer. It is you just can't walk into somebody and say, oh my gosh, we've gone to online learning and we have financial issues and I have to let you go today. You might not be able to do that if you have a contract. Now, you may have provided for that in your contract, but if something comes up and you haven't taken care of it in your contractual language, then your contract is going to be a burden rather than a blessing. Same thing with your right to change different types of conditions. You might find yourself where you can't even reassign a teacher because of the way your contract has been written. We touched on payment if you violate any of the termination terms. And we talked about how hard it is to keep an employee actually in your employ if that is not where the employee wants to be. And then ultimately, the party that drafts a contract, which is always an employer, is the party that is going to be judged most harshly if there is any type of disagreement or spat, or the contract is vague in any one way or another. It's going to be construed against the drafter or employer is what we say. Is there anybody who's willing to share a contract, either godsend or nightmare, someplace where a contract really helped you out or really caused you a lot of aggravation?
Well, I have a question.
Sure.
How about electronic contracts?
Electronic is just fine. So that the notion of any electronic document these days should not be scary, because electronic signatures, one, they're things so formal as, a process like DocuSign, where it is very well documented that somebody signed. But with the right language, electronic signature is fine. So sending somebody an electronic document, either just an email or an email with an attachment, and having them type their name on that attachment, or a PDF that they can type their name into and the date and send it back. All of that has enough of an electronic trail that we don't have problems with it. And at least within employment law, it is so seldom that we end up in litigation and the employee or former employee is alleging, that's not me, I didn't sign that. And we enforce hundreds of important documents like arbitration agreements. I guess firm-wide we probably enforce hundreds a month, but as a lawyer, my friends within the Atlanta office, we probably enforce 100 or so a year. And we might hear that argument one time, and it's usually quickly shut down. So electronic enrollment contracts, electronic employment contracts, done the right way, are great. Good question, Cherry.
Definitely eliminates the file cabinets.
Yes. And that is a trend we're seeing in all businesses with all documents, and including employment-related documents, everything from applications for employment, support documentation, fully electronic personnel files. Paperless has long been a trend, and we're not seeing that slow down. Any other contract problems or pros that you want to share? All right, I know I've only got a minute or so, so let's take a look at a few important contract terms. Within an employment contract, obviously you want to cover compensation. You want to cover that very clearly, the amount of time that it covers. What happens if somebody is on a leave of absence? Is that going to be paid or unpaid? Do you allow any types of loans? And could you recapture loan repayment out of the compensation that you would otherwise owe to an employee? What about force majeure? You know, I'm sure all of us have been reading force majeure clauses for our entire professional careers and going, oh, I don't need to worry about that. And lo and behold, look, the world of contracting is forever changed because of the last now close to 4 months of our lives, right? So paying attention to those details, thinking about what ifs. When an employee and an employer come together, much like people who are about to get married, everybody's happy. Everybody says, oh, we like each other so much. We're such good people. This will never go wrong. It's easy to say, I don't need to think about the small stuff. I don't need to sweat the small stuff. We'll all sort this out if it ever matters. By the time it matters, everybody's pissed. Nobody's happy. Everybody's wrong. And that's when you really wish you would put in the time and effort to iron out those little details. So think about the little things, additional duties. William mentioned that a contract can be a really good way to take care of all the other services that this professional might provide to the school and how they'll be compensated for those things. Basic benefits, and sometimes that means just the mere fact we will provide health and dental insurance on the same terms and conditions as provided to all other employees in substantially similar positions. That's probably as specific as you want to be on that type of benefit. But then there are many other benefits where you might choose to use the contract as your primary information delivery vehicle, but not necessarily. So tuition remission, housing, vacation, sick days, you can cover those in your contract, or your contract could just refer to the employee handbook. So think about, but try not to do everything everywhere, because if you duplicate information, you're constantly having to update and keep it uniform, because the last thing you want is a supposed contract saying you get 10 vacation days and then a handbook that says you get 8 vacation days or 15. It looks bad. You don't look like a professional organization if all your documents aren't consistent. Think about the school year, and then think about reasons for termination, and we'll finish up with this slide. Lots of things to think about, and probably some of the most important issues in a contract is, as the employer, how can we get out of this contract if we need to? Hopefully at will, we'll take care of it for you. But you might have reasonable cause, good cause, you might have a no cause type language. So lots of different things to think about. And thanks to, I think it was Suzette's great question about telling somebody their contract is not renewed. We already know that there can be problems and litigation that come out of that. And then the last thing, lots of other duties or terms that could be included in that contract. Think about confidentiality, intellectual property. I know a couple of the schools I work with have very proprietary methods of teaching and educating, and they work to protect that property and how teachers would or wouldn't use that information if they move on from the school. So lots of different things that you can think about that can be covered in those contracts. And I don't want to go too late because I think I'm running into a break. I need Diane to tell me whether there's a break or another speaker after me, but I want to be mindful of that. And then I can answer questions for you all later today during our wisdom session.
You will be the last presenter today. We are going into a break in a couple minutes, but if you want to get through the last of your slides, I think that's
okay.
Great.
All right. Well, how about the last thing I have is managing the process. Do think about using counsel to help you get a good base document. Ideally, somebody who specializes in employment law, because this is an employment contract. And then don't make major changes to it without getting more help. And the other thing to always ask yourself, every single document you use that's related to an employee, whether it's an employment application, a disciplinary warning form, your contract, just because it was perfect once doesn't mean it's still perfect. If you have brought a document with you to your current school from a past school, don't assume it's perfect. There could be a state law difference. Things could have changed. The motivations and drivers at the first school could be different from the motivations and drivers at the current school. So all employment documents should be living, breathing, growing documents that just get better and better. I like to call it incorporating life's lessons, sort of like we'll all be paying more attention to force majeure clauses, and also legal developments. Today, we just got new legally protected categories from the Supreme Court's decision. So, employment law is constantly evolving. If both the head and the employee are going to sign agreements, I actually like to see the head sign after the employee, which almost never happens. But as a head, if you have signed off on a document and your employee goes through it, marking things out and initialing them and signing it and sending it back to you, what have you done? You have put the employee in a position of being able to write their own document, and now we have to argue about that, and it's just awkward. So make it, if it's a contract, make it look like a contract, have the employee sign it first and then have your head sign it. And be sure that all your copies are in one place where you can easily find them. And that's whether you're using paper copies or electronic copies. So it's fine to, especially with electronic copies, it's so easy. Here are all of my contracts for the 2021 school year. And have a copy of all those in each employee's personnel file so that they're easy to find no matter how you want to get to them. And that was it. And I'm sure you all do have questions, but I imagine Diane will direct us to take our break and then do those questions during Wine and Wisdom.